Thank you, Your Honor.
You're welcome. Okay, you may proceed.
Good morning. May it please the court, I am Mark Metzinger, and I am here representing the appellant Matthew Sysack in this custody case. I'd like to reserve 2 minutes for rebuttal, please. Thank you. As an initial matter, there's a couple housekeeping things I'd like to advise the court of. First is, I am very new to this case. I didn't do the briefing. I wasn't part of the trial. I have very limited knowledge other than what you have as far as reviewing the record, what transpired. I say that only to point out that I'll try to answer your questions if I can, but there's a lot that I don't have firsthand knowledge of.
Fortunately, we're all on the same page because we can only consider what's in the record.
Exactly, exactly. So maybe that's helpful in some ways. I find it difficult from my position.
I'll help. I've been around a long time.
Well, and I was going to point out, Mr. Turbo, I believe, has been involved in this matter since almost the beginning, if not the beginning. One other thing, Mr. Turbo has filed a motion for attorney's fees in the Court of Appeals, and I believe my client never opposed that. I would like to either do one of two things. I'd ask the court for additional time to file an opposition to that. I believe the court issued an order saying they'd hold that until the end of the matter. I'd like the opportunity to file an opposition, or if the court wants to hear argument on it today, I'm prepared somewhat to provide some argument on that.
Counsel, you have no objection if she files a motion opposing it, do you?
Of course.
Thank you, appreciate that.
Thank you.
So why don't you make sure you file that within 10 days of this argument?
I will do that. Thank you.
That issue was deferred, wasn't it?
I'm sorry?
That issue was deferred. You're not planning to hear anything about that today, are you?
No, not at all. But I'm going to give her an opportunity to respond.
Okay.
Thank you. I appreciate that. As we're all aware, we're here on a custody matter regarding my client's appeal of the trial court's decision to adopt a magistrate's order which denied Mr. Sysack's motion for a change in custody. A couple of things about that. I think it's important to note from the beginning that my client's motion was initially filed in May of 2012, which was then withdrawn by agreement, and then refiled an amended motion on July 5th of 2012. The hearing in this matter didn't take place till August 15th and 16th of 2013, more than a year later. And then the trial court didn't issue a ruling until April 27th of 2015. So almost 3 years passed in the time between the filing and the final appealable order. I think it's important, and I understand this isn't in the briefing, but I wanted to make a point of it because I think in custody cases it's critical that the court act swiftly to prevent the opportunity for any other mishaps, I'll say it nicely, to occur. 3 years in this case, pardon me, elapsed between the time of filing and the final order. During that time, many things happened that we don't want to see happen in custody cases. And I know a lot of these, this is not before the court, but I want the court to be aware of a few things in particular. One, Mr. Sysack now has supervised visits only with his son because of claims the mother made, unfounded claims.
But that's not the record. It's just as Judge Moore cautioned you at the beginning, we cannot consider it.
I understand that. I just wanted, my point is that 3 years is too long. To me, it's not in the briefing, but I think it amounts to plain error. I think that...
Were any motions filed or any original actions to try to compel the court to rule on the issue?
In intervening, in the...
Like a mandamus or something?
I don't believe so. I came in within the past month or so, and so no, I don't believe so.
No, I understand that you could have done it, but I'm just...
Based on my review of the record, no writs have been filed, and I think that might have been appropriate. In fact, I think there's matters pending now that it might be appropriate to do the same thing. In any event, I'd like the court to take notice of that time span because in custody cases in particular, like I said, I don't mean to be repetitive, but I think it's critical that these kids get some sort of resolution and can have some sort of continuity and an understanding of what that's going to be. 3 years is entirely too long to wait. I guess I'll address the first assignment of error that's in the brief, the only assignment of error, which is that the trial court erred in finding no change of circumstances occurred, resulting in the wrongful dismissal of plaintiff's motion to reallocate parental rights. I think the trial court erred in a couple of ways here. First of all, there was evidence that the mother has manipulated the parenting time. She admitted on the record that she does not always provide information regarding doctor's appointments and school events. My client testified that he frequently would get notices of these events or occurrences, medical appointments, but too late for him to do anything about it. He couldn't get off work, he couldn't get there. Very disturbing to the child when the child was relying on the father to be there and the father didn't show up. Another instance is, well, let me go back. Change in circumstance really is required to find the modification in custody that my client sought. I think the intent of finding a change in circumstance is, like I said, to provide continuity and allow the child to have some reliance on what his parents are doing with regard to his care. My client frequently would go to school to pick up the kid as was their agreement, and the child wouldn't be there. Mother would remove him early and not let father know that she was picking him up early. She manipulated school calendars so as to extend her parenting time and reduce my client's parenting time. She regularly failed to put things in the Our Family Wizard, which is the communication method that they ultimately began using. Are you familiar with Our Family Wizard?
We've had that argument
Okay.
before us
So
before,
it's-
but I
it's-
thought that wasn't actually instituted until after this motion for reallocation of parental rights.
You know what? That's an institutional thing. I thought it was right around the same time that they started using it.
We'll look at the record.
Regardless, emails she wouldn't respond to. She didn't send timely notices. They did communicate text and email quite regularly. Unfortunately, like I said, it was almost always too late for my client to do anything about it. The child was provided a cell phone by his father so that the father could have easy contact with the child. And the order at the time in place was that they could have telephone calls regularly. My client would not call the child on days he had possession of the child, but would speak to the child when the child was with mother. Mother answered the child's phone, which she knew and which did in fact aggravate my client. She prevented him from answering it, at least that's the assumption that was made, because the child didn't answer the phone.
And I forget, how old was the child at this
I
time?
think he was 9 at the time this all started. Is that right, Larry?
7.
7, I'm sorry, 7. I apologize. 7 years old. Old enough to talk on the phone and to communicate. Maybe not old enough as we as parents would want our child to have a cell phone for regular purposes, but for purposes of communicating with his father, I do think it was appropriate at the time.
The record, or the brief indicates that father withdrew the cell phone at some point.
Father did take the cell phone away because it ended up being more of an aggravation than a tool, a useful tool. As I said, mother would answer and that would aggravate father. The child wouldn't answer and there was some suspicion that she was not letting him answer the phone.
And it may have been just a process of it's a 7-year-old. He's not going to be carrying a cell phone around with him and it's laying on the counter and mom answers it.
Your Honor, that's a very good point. And actually, I believe that was probably true some of the time. I also think some of the other times that that's not exactly how it happened. And it's hard to get a 7-year-old or a 17-year-old to do what you think they should do, and I understand that as well. But in a custody case like this, I think it's important for the child to have the expectation that the other parent is going to be calling you and you need to at least say hello. I don't think that that's necessarily out of line with a 7-year-old, now 11-year-old.
So what precisely were the changes in circumstances? It was not clear from the brief.
Well, based on, and I would have to agree with you on that, Your Honor, I apologize for that. Based on my review of the record, I think that there's not any one thing that amounted to a change in circumstance. I think it was a collection of things. I think it was the fact that mother manipulated the parenting plan. I think it was the fact that the child wasn't allowed to contact his father on the phone that was provided to him. I think there was a lot of discussion in the record about the 1 hour of time that father missed over Thanksgiving break, and I don't know if that stood out to you at all. But what happened with that is father was very excited. He had bought tickets to go see some pro wrestler that the kid was enamored with. And mother said, oh no, you can't go, we're going out of town. So father had spent a couple $100s on this and wasn't able to enjoy this with his son. So I think everything collectively results in a change of a circumstance.
Well, isn't that more appropriate maybe for a motion for contempt instead of a change of circumstances? The
Well,
things that you've been talking about?
the parties had engaged in significant motion practice. There were mutual motions to show cause, mutual motions to terminate custody, up and continuing to this day. It's occurring. So I think, and again, I wasn't there, so I wasn't part of the strategizing, but I believe on my client's part, it was really an attempt to try to get custody so that he could provide a stable, consistent, loving environment for his son.
And I can appreciate that, but wouldn't you agree that the majority of time these type of issues are handled through the consent process?
I'm sorry, I'm having a hard time
I'm
hearing.
sorry, now I need to talk up louder, speak up louder. I said, wouldn't you agree that usually though those type of things are handled more in a contempt motion rather than constituting necessarily change of circumstances? If one party's not abiding by the terms of the agreement.
Yes, but how many of those do you get to before you decide that you need to make a change in custody as a parent? How many of those do you go through motion after motion?
Well, it depends on whether you win or lose, I guess.
Well, and how quickly the court acts. And in this case, the lower court has been very slow, at least by my looking at the record, very slow on ruling on any of these things. And this particular hearing is an example of that. I mean, 3 years is out of line. And a lot of things, like you said, motions can be filed, and they were. I don't think that gets to a change of custody. I don't think the court can order a change of custody on a contempt motion without showing a change of circumstance in any event. There was some discussion about the guardian ad litem report, and the parties submitted to a psychological evaluation. Dr. Deborah Karicki did an analysis. And it's interesting to me, I found in both reports that it said that the child enjoyed a good relationship with both his mother and his father. He was comfortable with both parents. He was comfortable with the extended family. He was happy and pretty well adjusted. And then almost immediately after the hearing, that began to change. After the August 2013 hearing, that began to change. I think, again,
You're almost
exactly
into your 2 minutes, I want to warn you.
I'm what?
You're approaching your 2 minutes.
Okay, thank you. I guess in closing for this part, I just want to say, this is a father who cares deeply about his son. I think there's communication issues between the parents that I think can be resolved. I think the trial court, based on the evidence before it, made a mistake. They should have found a change in custody. They should not have granted Mr. Turbo's 41B2 motion to dismiss, and should have proceeded to an analysis of the best interest of the child. Thank you. Thank you.
You may proceed.
Good morning. May it please the court. I admit that I've gotten to the age where I can't see with my glasses you, and I can't see my paper without my glasses, so I have these bifocals, and I can't see either one.
I understand.
Oh, I'm sure that you're well too young for Your Honor, there's one thing that, well, it's not before the court, there's one thing that, only one thing I think that I would agree with counsel on, and that's that the process in this case has been very, very slow and very long, and speedier disposition might, well, I'm not sure it would do much, but it might slow some things down. Just so you know that in my motions, pleadings, Bible, journal, there's 197 there's 197 entries, so, motions, briefs, orders, and notices. Many of those has come since this hearing. It may be telling that while Ms. Metzinger is new to the case, it might be telling, not that I'm so great, that I've been around since 2009 or 2010, at least one series of motions prior to the ones that are before the court. I might mention that while these motions are pending, or while the objection period was pending, and while the appeal period is pending, there's been a whole new flurry of motions filed by both sides. There are, in my mind, I've been doing divorce work for a long time, though this isn't technically a divorce, it's just a custody case. Two kinds of cases: those that the lawyers see get resolved and never come back, and those where the phone never stops. Unfortunately, this is a case where it never stops. We, of course, not objective about this, but we, of course, believe it is substantially caused by the actions and inactions of the plaintiff in the case, who is the appellant before you.
Is there a mediation in as part of the...
I'm sorry?
Is there a mediation available?
Well, the answer, Your Honor, is yes, but that will bring us to lots of issues that are not before the court presently. Ms. Metzinger made brief mention to the fact that Father now has supervised visitation. The court will note that in the judgment entry of the judge, at the conclusion of this case, she ordered a couple of things that I don't recall being in the magistrate's decision. One was use of our family wizard, which was not used, though it was recommended by the guardian ad litem sometime before the formal decision of the court. I can tell you that Mr. Sysack refused to use it.
Well, again, don't tell us anything, it's not in the record.
No, it's not in the record.
Okay, so we
I don't
don't
want
want
to,
to know.
I mean.
We might want to know, but we can't know.
Okay, well, and I know I have 15 minutes, and I know I have 15 minutes and not 2 hours, so let me just try and address what this is. You know, it's our opinion, Your Honor, that this appeal has no merit. That the motions that brought this case, that are now before this court, motions filed by the appellant in the underlying case, had no merit. The trial court, after extensive hearings in briefing, the magistrate found that the case had no merit. There were motions, when counsel says that the motions were filed and dismissed, in fact what happened is that it appeared that the initial motions were filed including an order, a request for an emergency order, based upon the fact that it was alleged in the motion that Mrs. Ciulla, keep the names straight, Ms. Ciulla had an occasion where she was so drunk that she lost control of her bodily functions. The police, that hearing didn't go forward because the police reports didn't support that. So at that point, Mr. Sysack obtained a new lawyer, I believe, and filed an amended motion, which is the motion that actually went forward. Several branches of a motion that actually went forward. That issue was removed, but that was really the only issue. That motion asked for a psychological evaluation, which he got. It claimed that Ms. Sysack is an alcohol problem and a drug problem. It claimed that his telephone issue, that he couldn't use the telephone. He was fired, his child wouldn't answer the telephone, and he claimed that his visitation was interfered with. Basically, all of the issues that are before you. Your Honor, I believe that the appellant, even in their appellate brief, though we can't blame Ms. Metzinger, she didn't write it, the facts in it itself mislead the court, and we had spent a considerable amount of time in our statement of facts, which I don't generally do as an appellee, correcting or pointing out things that they seem to have missed in the record. The appellant's problems with his visitation are substantially of his own making, not my client's making. And you can tell that from the record. Of note, the child is presently on record saying he doesn't want to visit with his father at all. He's on record saying that. Again, that's post of this case.
Try to confine yourself to what's in the record, okay? I appreciate that.
You know, the first point is that the trial court abused its discretion in coming up with the decision it did. And, you know, this isn't a new issue before. Abuse of discretion is always a tough issue. It's often an issue in custody and family law cases. And, you know, and the truth is that the law says that the trial court has broad discretion in the allocation of parental rights and responsibilities, and that this body, the Ninth District, in a case called Miller versus Miller, in fact said that, you know. The trial court has to be afforded utmost respect for its decisions, because they're the ones who hear the evidence, they're the ones who view the demeanor of the parties, they're the ones who see the facts, and the Court of Appeals gets to read the brief. I've read this brief, I've read many briefs. Often the tenor of the case doesn't really come through in the printed record. So, you know, and the Court of Appeals, by the law, not by me saying this, because I never tell judges they can't do something. I learned that lesson as a first-year lawyer. You know, may not reverse absent finding abuse of discretion. That means that you have to find that the trial court's issue was arbitrary or unreasonable or unconscionable. It's the Blakemore case. The Blakemore case is probably the most often cited case in a domestic situation. You know, and the statute is well known, 310904, and it says that the court shall not modify unless it finds that there were facts that are unknown or arisen since the last decree that would make it in order to have a change of circumstances. And then, even if they find a change of circumstances, they have to find it would be in the best interest of the child to move custody. Well, in this case, as is known, at the close of the plaintiff's case, his motion to modify the custody, motion to modify the allocation of parental rights and responsibility was dismissed by the court. And in its brief, it is stated that the court never even got to the best interest test, but in fact, if you read the magistrate's decision and read the court's decision, judgment entry, and read the court's decision on the objections, it says that the court did review the factors for best interest, even though they didn't find a change of circumstance and did not find it would be in the best interest of the child to move. Okay?
So, and basically, in dicta, the court said, you know, even if I were to find that there were a change of circumstances.
Yes. He said even if we did find a change of circumstances, we wouldn't have found, we didn't get there, but even if we did, we wouldn't have found the best interest. You know, allegations are made that the child is living in an unstable environment, and that the house, as an example, this is how they kind of misstate things, and that the house is in foreclosure. Well, I think her condominium did go into foreclosure, but only after she married and moved, only after Mr. Sysack knew that the child wasn't living in that house that was in foreclosure. He knew that the child was living in North Olmsted in the marital residence, which happened to be the stepfather's residence prior to the marriage. So, you know, there's just nothing in his arguments that have any substance to the fact that there's any sort of abuse of discretion in the issue of the court. You know, it's the intent of the statute to try and prevent a child from being a footballer, being in a tug of war between the parents. I'm afraid that this child, notwithstanding that, is in a tug of war between the parents, at least during my period of time on this case. You know, and even if the court were to find, if they didn't find a change of circumstance, but even if they were, they have to find more than a slight or inconsequential change of circumstance. Mr. Sysack, as I recall, complains about telephone contact. It's hard to keep out of my mind what's been going on in this case. The court decided in 2000, and this is in the record, if you look at the docket of the court, this case was originally decided in 2005. The child was born in 2005. It was originally decided, there was an allocation of parental rights by the then juvenile court in Medina. Apparently they've gone to a family court situation, and so it's all the domestic relations court now. And Mrs. Sysack, there wasn't a shared parenting plan, but Mr. Sysack thinks there is, by what he says. She was always the sole custodian of the child, and that lasted until, coincidentally, Ms. Ciulla became engaged to her present husband. At that time, a series of motions was filed, and in those motions, which are in the, I don't know how much of the record this court gets, but in those motions, Mr. Sysack alleged that she was drinking and using drugs of abuse. Court ordered independent testing. Testing came back negative. It might be interesting to know that Mr. Sysack is a recovering alcoholic. During the entire time of this case, he's not drinking. I mean, but he seems to have a very he seems
Heightened awareness?
Yeah, I would say it seems to me that, you know, if you go to a restaurant and order a pizza and a beer, that you're drinking excessively. If you have Mrs. Ciulla is Italian. I don't want to make light of this, but if you sit down for dinner and have a glass of red wine, that's he seems to have problems with that. He admits that he interrogated the child continuously at every visit. He admitted that to Dr. Kuricki. He admitted that to the guardian ad litem, which in fact is a violation of all of their agreements. But in the case, in the settlement of the case before this, this set of motions, he alleged that she had an alcohol problem. He alleged she had a drug problem. He alleged that they had a problem with the telephone. He alleged that she interfered with his visitation. I will admit that in the distant past, they had a very difficult parenting plan. It was very difficult to figure out where the child was supposed to be, and that has something to do with the fact that it was a progressive plan, meaning based upon the age of the child, visitation things changed, and it got very confusing. I want to mention one thing about vacations.
And you're down to less than a minute.
Okay, well, then I'll move on to Rule 41. They allege that there's a violation of Rule 41, and that under Rule 41, Your Honor, which is the motion to dismiss that I made in this case, the court has to make a decision, but unlike with a jury, they have to the decision they make is somewhat different, and they're obligated to review the evidence and determine whether or not the plaintiff has made his case. And that review was done, and in fact, the court found that the plaintiff had not proven his case. It's not even by a prime, it's not. And at that point, he dismissed the case. I mean, it may be in the record that it wasn't a split-second decision. The court, in fact, took overnight to make a decision about that and announced a decision the next day. So he did have time to review. I think I'm out of time, and therefore I would just say again that I believe that the underlying motions had no merit. I believe that the record reveals that. I believe that therefore this appeal has no merit, and that that this court should overrule the appeal and affirm the decision of the trial court.
Thank you. You have just about a minute and a half left.
Okay, thank you. A couple of things I wanted to give the court the case on the unusual delay to refer to as Gordon v. Gordon, 1973, 33 Ohio Act, 2nd, 237. It is a 3rd district case, but it basically said that delay in resolving who shall have custody is ordinarily a source of continuing concern, if not anguish, for the child as well as the parents. A couple of things. Mr. Turbo said that I take note with. The court found that, didn't find that there was no merit to my client's claims. He found that there was insufficient evidence to show a change in circumstance. I think those are two different things. I think that the court narrowed the period of information, the period of time in which evidence would be produced, about which evidence would be produced. So it was a very limited period of time when my client was foreclosed from introducing additional evidence, such as emails, which I think was addressed in the appellant's brief. Lastly, I don't recall reading in Dr. Kuricki's report or in the guardian ad litem's report that my client mercilessly interrogated his child. I think there was one occasion where it was reported that mother had done something in an email, and my client and his brother communicated, using bad judgment perhaps, about the mother and maybe said negative things about the mother, but there was nothing beyond that in the reports that I saw that would suggest that the child was interrogated. At this point, I'd like to thank you all, and we'd ask the court to reverse and remand for further proceedings.
Thank you very much.
Thank you.
Thank you to both sides for your presentations to the court. The court will take the matter under advisement and issue a written opinion, which will be sent to both sides, as well as the opinion will be released on our website and Supreme Court website. Thank you.
Thank you.